Jason Rzucidlo reporting from the Adat Shalom Synagogue in Farmington Hills. Stay tuned for remarks from Robert Sedler, a WSU law professor who will discuss the candidates for Michigan Supreme Court.
Discuss the candidates per se. He's going to discuss the importance of the race and the issues that we all have to think about. Professor Sedler.
Thank you. It's always a pleasure to speak at programs sponsored by the National Council of Jewish Women, and I've spoken here before and to various other Jewish groups. It's an especial pleasure for me today to be on the program with my younger colleague, Justin Long. Justin is one of our bright stars that we have been fortunate enough to recruit at Wayne State, and as we grow older and older, we look forward to see other people taking our place. When the media reports on the courts, they invariably talk about the United States Supreme Court, which decides important constitutional questions. In our constitutional system, we have a dual system of federal courts and state courts. But for most people, the important courts are the state courts. It's the state courts that deal with the questions in our everyday lives. This is what they handle cases about automobile accidents, landlord-tenant disputes, divorce, family matters. We have the district court, which is the lowest court. We have the circuit court for Oakland County. We have the Court of Appeals. And at the apex of the Michigan judicial system is the Michigan Supreme Court. Just as the United States Supreme Court is supreme in deciding questions of the federal Constitution and federal law, the Michigan Supreme Court is supreme in deciding questions of Michigan law. And it's Michigan law that is of most importance to everyday people, I should say people in their everyday lives. We have a state constitution, of course, that parallels the federal constitution, except while the federal constitution is over 200 years old and consists of 7 articles and 27 amendments, the Michigan Constitution is very detailed. As you might have thought, some of you may have paid attention to the first constitutional convention that led to the Constitution in 1963. I wasn't in Michigan at that time, but that is the Constitution that we live under. Article 6 regulates the judicial branch. And in Michigan, we have had a long history of electing our state court judges. Unlike federal judges who are appointed by the president and must be confirmed by the Senate, the people of Michigan have basically said, we want to elect our judges. And while there are periodically proposals to change the method of selection, in my opinion, you're not going to get anywhere because we have a long constitutional tradition of electing judges. And that was embodied in the 1963 Constitution. However, there is a difference when it comes to lower court judges and justices of the Michigan Supreme Court. Under the Constitution, lower court judges are to be elected and nominated in nonpartisan elections as provided by law. When it comes to the 7 justices of the Supreme Court who are elected for 8-year terms, it reads slightly different. It says elected at nonpartisan elections and nominated as provided by law. What the legislature has done is to provide primarily for political party nominations. So at their conventions in September, the Democrats nominated 2 people and the Republicans nominated 2 people. Now when you go to vote, you won't know who's who because they are to be elected in nonpartisan elections. The Constitution also provides that incumbent justices and judges run with the the designation incumbent. Third parties can nominate candidates, and in fact, in the last election, the Libertarian candidate got 11% of the vote, which may have been enough to tip a close election. Also, third parties can nominate a candidate, as I said. In 1972, Charles Levin, who many of you know, was a judge of the Michigan Court of Appeals. He wanted to run for the Supreme Court, but he wasn't about to get the Democratic nomination. So he formed a new political party called the Justice Party, whose only purpose was to get Charles Levin on the ballot for Michigan Supreme Court. And he won the election. Once one is an incumbent, 6 months before the election, the incumbent can can self-nominate. Where there is a vacancy, the vacancy is filled by the governor by appointment, and when the governor makes an appointment, as you recently did for Justice Davis, Justice Davis runs with the incumbent designation on the ballot. So that is the structure of electing judges in Michigan. Now I'm going to candidly discuss the politics and ideology. I will try to be as neutral as I can, but those of you who know me know that I'm not neutral in politics and ideology. Beginning in 1998, Justice Engler appointed 3 justices to a vacancy. They were elected as incumbent. A 4th justice who had been on the Court of Appeals was elected to the Supreme Court, and you had what may be called a conservative majority. Now I want to say something about political party nominations. One of the things that this ensures is that all the candidates will be qualified and that they will have nothing in their background personally that can be used for personal attacks. The 4 candidates nominated this time, Justice Davis, an incumbent, Judge Denise Langford Morris of Open Circuit, Democratic candidates, Justice Robert Young, and a Republican nominee who's an incumbent, and Judge Mary Beth Kelly of Chief Judge Wayne Circuit Court are all highly qualified people. So you're not going to have, well, for this choice, well, this person really wouldn't make a good justice. They are all very well qualified. And this was true of the 4 people that Governor Engler nominated, people that I know very well. They are very qualified. They are also very conservative. And they believed that it was necessary to make a lot of changes in Michigan law, which they did. In a 10-year period, the Michigan Supreme Court overruled 38 decisions. In the preceding period, 10-year period, they only overruled 8. And the courts will sometimes overrule decisions, but not very often. There's 34 decisions where you had the conservative justices and the liberal justice dissenting. In every one of the cases, every civil case, the effect of the overruling decision was to favor insurance companies, employers, doctors, defendants, manufacturers, and so forth. In every criminal case, the effect was to favor the prosecution. Now that the court turned in the 2008 election, where in a very unusual thing, an incumbent, Chief Justice Taylor, was defeated by Justice Diane Hathaway. This made the court ideologically divided, with 3 liberal Democrats, 3 conservative Republicans, and Justice Weaver, who was originally elected as a Republican but broke with her conservative colleagues.